he can call and that they can call him, Mr. Bowers could be added to that list. I believe that there's a maximum of 20 for Mr. Bowman, given his conditions of confinement. And
Have
so
you
he would have
alleged
to.
that? Have you alleged that he requested a journalist to come in and that the journalist was denied request?
No, I have not. We've not needed to because, as I said, as a matter of fact, we have access already. Certainly, this case could have been brought by a family member or friend of Mr. Bowman that wanted to do exactly the same thing. They don't have the same, the same factual claims that we have. They don't have the same institutional interest in sharing the information that Mr. Bowman also wants to share. It is a unique fact about our case that our access at the moment is based on our legal relationship, but I don't believe it's one that's dispositive of the legal issue.
Let me assume, let's get over that issue. I understand that issue very clearly. Let's assume you have access. Then your argument, it's a First Amendment case, and you would agree that Turner applies to that.
I would not, Your Honor. And the reason why is that the justification for this policy is exclusively based on things happening outside the prison. So this is a restriction on outgoing speech, on speech leaving the prison. And under Thornburg versus Abbott, Martinez continues to apply to outgoing speech.
I don't think you're right about it just affecting the outside. The argument, they have a list of reasons, and the argument, one of the main ones that seems to stick out is that this would create a notoriety for this particular inmate, which is a prison, a legitimate penological issue. There would also be others, as they talk about prison resources and the fact that there are other avenues for this, but address that notoriety, which it does not fall into the category that it's external from the prison.
Sure. The notoriety was raised in an affidavit from Mr. Antonelli, who does not, I would encourage the court to look closely at that affidavit. It does not assert that concerns about notoriety are actually animating this policy. It merely says that if SEDC did not enforce any restrictions on the publication of inmate speech, there could be concerns about notoriety. But
let's assume that we realize that the notoriety is an issue. Take us there.
Yeah, I would say that this is, it furthers too little and suppresses too much, Your Honor. So for example, as is in the record already, SEDC already provides recorded conversations of its most notorious prisoners to the press. It did so for Mr. Murdoch. It both punished Mr. Murdoch and Mr. Murdoch's attorney for sharing a publication, sharing a recording of his speech, while at the same time providing other recorded phone calls to the press of Mr. Murdoch. The same thing happened with Susan Smith subsequent to the end of briefing here. And so the prison can't have it both ways. It can't say the only way we can enforce this categorical sweeping ban, oh, by the way, this is the only prison system in the country that enforces it this way, but this is the only way we can ensure that there isn't notoriety, while on the other hand, providing recordings to the press of its most notorious prisoners. Does the court have any follow-up questions to that on that one? Okay. I do want to make sure that we don't lose sight of the 12v6 issue here, and that there's both a facial challenge and an as-applied challenge. Under the 12v6 issue, it really is a simple one. The question is merely whether under Martinez or Turner, can a prison enforce a sweeping categorical restriction on speech based on a non-penological interest in shielding crime victims from potentially observing speech that they might find upsetting? Taking our well-pleaded allegations as true, the challenge policy violates the first prong of Turner and Martinez, and the district court was wrong to dismiss.
So, counsel, in making this argument, you're assuming that the issues Judge Niemeyer asked you about, the raising of notoriety within the prison setting and the disruption that can cause to prison life are not viable rationales.
For the purposes of 12b6, the court should look at the complaint, the well-pleaded allegations contained therein, and what we assert, and we use Defendant Director Sterling's own public representations to make this allegation, is that the policy being challenged here is rooted in victims' rights and is meant to ensure that crime victims do not receive upsetting speech. That is the only justification publicly put forward by defendant Sterling until he was sued about this. And it's the only allegation contained in the complaint. So for the purposes of the motion to dismiss,
I mean,
the four
that's a
corners
little
of
bit,
the complaint. Excuse me.
that's like a little bit like the Congress passing a law, and then one congressman comes out who sponsored the law and explains what it means. It seems to me a policy is a policy, and we read the policy on its face. Sure, it's maybe evidence to have somebody explain what he thought was the best or the most serious issue that the policy protected, but it certainly wouldn't exclude other matters that are inherent in the policy.
Two responses to that, Judge Niemeyer. The first is that under 12b6, the court should look to the four corners of the complaint for the factual assertions contained therein. Certainly, at a summary judgment stage or at a trial, we would have the burden to prove, or I guess the defendants actually would have the burden to prove what the actual interests are, and our burden of persuasion would apply. But even beyond that, it's not, I would reject the hypothetical that this is like one elected official explaining a policy to which he voted for. This is a First Amendment issue, and so there's always concerns of chill. And so when the leading enforcement entity is publicly declaring this is what our policy does and this is why it does that, chill emanates from that really aggressive explanation of what's prohibited in a way that it isn't true of an individual legislator saying what a policy they voted for it does or does not do. I see that my time is up. So.
Yeah. Thank you, Mr. Channing. All right, Mr. Hall, we'll hear from you.
Good morning, Judge Niemeyer, members of the court, and may it please the court. I have the privilege of representing Mr. Sterling in his official capacity as the executive director of the Department of Corrections. You'll hear me refer to SCDC rather than director, but obviously I mean them interchangeably here. The tug of war that we seem to be having is one of access versus publication. And when the case law is construed and you look at Pell, Saxby, and Houchins, all of which involved press access, media access, the holding is clear, and that is that the press doesn't get any additional rights than that which the public gets. Judge Niemeyer.
Well, let me ask you this question. I understand that. We understand those cases, and that's one of your big prongs is access. The argument, I guess, is the ACLU has several functions as an institution. One of them is to represent clients. And the other is to engage in public discourse and public debate on the death penalty. And they say that they have access by reason of their attorney-client privilege with Mr. Bowman. And then they're going to use that access to carry out another function, which is the journalistic function. How do you address that?
Your Honor, first, the regulation itself, when it speaks of attorney access, makes it clear that it is for the purposes of interviewing inmates for purposes of an investigation or pending legal action. So they say they have access, but they have access for the purposes of the attorney-client function. They make clear in the complaint at paragraph 28 that when Bowers interviews individuals that the ACLU represents in an attorney-client capacity, he does not give legal advice, and the ACLU does not claim attorney-client privilege or other protections that attach to attorney-client communications. So they're trying to have it both ways. It was unclear, I will say, from the briefs. I think the court may have seen sort of a modulation of the capacity in which the ACLU speaks. It was clear in the complaint that it was absolutely in the news gathering context, and that began to morph a little bit in the reply brief. If you look at just the attorney hat, they make it clear in the complaint that they don't come wearing that attorney hat. And if they did, the reg says that attorney hat can only be utilized for the purposes of an investigation or pending legal action. So they wouldn't actually have access to masquerade as an attorney, but really be in the news gathering reporter context. Your Honor, can y'all hear me?
Yes.
Yes,
Okay, I'm
you
sorry.
may proceed.
Just want to
You
make
can
sure it
continue.
locked up.
Your transmission, video transmission is quite poor. It's delayed and it's fractured, but we hear your voice.
Okay, I'm sorry. If you would like, I can turn the camera off. I don't know if that would help. It
No,
might be
this is
easier on
all
your
right.
eyes. Okay,
No,
thank
it's all
you.
right.
Your Honor, I would go on to say that even if when you look at Martinez and you look at Safley, each of those really construe inmate rights. In neither of those cases do you have press plaintiffs. What you have is a discussion, for instance, in Turner about inmate to inmate correspondence. And in Martinez, obviously, you've got a class action about prison mail censorship. Neither of those cases address the external dimension of a news gathering organization coming in. And when you get to Houchins, the court made clear, again, in 1978, that the press gets only what the public gets. And the Houchins court was very clear to distinguish Grosjean and Mills that dealt with the freedom of the press to communicate information and said, hey, that's not what this is. This is about access. I would also point out in the Saxby holding, the court says it's unnecessary to engage in any delicate balancing of such people considerations against the legitimate demands of the First Amendment. And as the court knows, that was a 5-4 decision, and Justice Powell was the swinging vote in each of those. He was in the minority and dissented in Saxby. On the media dimension in the Pell case, he also dissented, making the media portion a 5-4 decision, and yet the inmate portion a 6-3 decision. So I don't think there's any lack of clarity about where the rub is in those cases. I went back and listened to the oral arguments in each of those cases. It's clear that the access issue is where the court loses Judge Powell and creates the 5-4 decision.
Counsel,
Yes, Your Honor.
sorry to cut you off. Can you address the telephone access point that your friend on the other side was making?
Well, it is true. Again, I think the first question I would ask myself, what hat are they wearing? Let's assume for a moment they're wearing the attorney-client hat. In the attorney-client context, obviously lawyers have unsupervised or unlistened to communication with their clients in incarceration. But again, they are in that legal capacity of an investigation and pending legal action, and the policy does not allow them to just go publish that. The plaintiffs point to the Murdaugh example, where the lawyer either misunderstood or misused the attorney-client access and attempted to broadcast that right. That obviously is violative of the policy. All right. Now, in the so again, that fits still in the Pell Saxby Houchins rubric, because it's not legitimate or legally obtained information. It's obtained by either mistake, inadvertence, or by simply violating the regulation.
Can the general public access Mr. Bowman by phone?
The general public can, within certain instances, have access with inmates. As Mr. Cheney alluded to, it varies from facility to facility.
Mr. Hall,
Yes,
let me interrupt you. I think the question is focusing on the distinction between physical access into the prison as opposed to a telephone call. And the question is, does the public have telephone access to Mr. Bowman, which would include the press?
It does not have telephone access to that would allow it to record and broadcast those communications. I'll refer to the example in the brief about the happy birthday call. All right. The notion is that if a prisoner were to leave a happy birthday message or sing happy birthday to a family member, that it would be outrageous for that to be something you couldn't put on your Facebook page. But again, the penological interests include concerns about articulating to others outside the prison activities that could affect the inside of the prison, gang-related violence, coordination of crime, escape plans, coded messages.
So is your point that even the general public, if they can, even those members of the general public who are allowed to speak to Mr. Bowman, if they exist, I'm not sure what the policy is outside of friends and family. I don't know that we have that in front of us, but that even those individuals cannot record and publish the conversation? Is that what you're saying?
That is correct, Your Honor. And
Okay.
we cite to those provisions in the record. You have at the Joint Appendix 56 through 58 provisions that speak to the prohibition on recording audio or video for anyone who has access.
So your view of the policy is that while it may permit some form of general access by the general public, there is no dispensation to publish anything that the general public may glean from that telephone access.
Yes, Your Honor. Let me make 2 points there. First, when I say general public, I don't mean I can just call anybody. I'm referring to people who are approved to communicate with the inmate. Okay, so I can't just call the prison and say, "Hey, I'd like to speak to inmate X. Can you get him on the phone?" Inmate X can have certain family members, clergy, others on a list. That's the subset about which I'm speaking. And with regard to that subset, Your Honor, no, they cannot record audio or visual, in this case, audio, and republish or rebroadcast that. That's the point that I'm trying to make.
So I take it
Is
your
there any-
argument would be that in that context, the general public is treated no differently than the press would be.
Absolutely, absolutely.
Okay.
And again, the reasons for that, the rationale is obvious. I articulated some of the concerns about security and order. But imagine for a moment if every one of those communications had to be monitored or they had to be on delay. Imagine the resources that would be required for the Department of Corrections if that were the case. If you've got an incitement of gang violence, or you've got a call to do harm to a witness, if that were to be included in that communication, how would you prevent that? Well, you presumably, I guess, could be like, the old days of mostly live TV, where you had a 6 or 7 second delay and somebody bleeped or cut the communication. Imagine the demands on prison resources if that were the case. And so again, it makes rational sense as well as legal sense why the prohibition exists.
As a
Anything
just a
further?
factual matter, is there a date set for this execution? I think originally the papers included a date, but now maybe that's up in the air. Do you know?
Your Honor, Mr. Cheney and I had a discussion about that this morning, and the date was set for the 6th of next month. Mr. Cheney alerted me this morning by phone call that an order had not issued from the Supreme Court last Friday as he anticipated, and asked, "Hey, has the date changed?" And the answer to his question and Your Honor's question is, I just simply don't know the answer.
Okay.
So I thought
What-
there was a representation somewhere, the execution was set for November 29th.
Your Honor, if the court will indulge me, I don't believe the date of the execution is relevant to the legal analysis, and so I've not focused there. I believe Mr. Cheney may be able to address that better than I can in terms of that sequence.
Right.
Anything further?
Your Honor, that's it, unless the court has additional questions.
All right, thank you, Mr. Hall. Mr. Cheney?
Thank you, Your Honor. And I want to clarify the record about the execution date as best as I can. When we filed our briefing and represented that it was November 29th, that was the information that was being distributed publicly. That date changed to December 6th. But the way South Carolina works is a death warrant is issued 4 weeks in advance by the state Supreme Court. The date that would have happened was this most recent Friday, and a death warrant did not issue. And so we are somewhat in limbo. There are pending arguments before the state Supreme Court about delaying further executions through the holiday season that the court hasn't taken any action on. But I did want to update the court about the status of the execution date is not as certain as we originally thought and had represented. It is the case that Mr. Bowman is now the very next person in line. And so the next execution that occurs in South Carolina will be of Mr. Bowman.
So as I understand it, then this is a pragmatic matter because we want to consider this, and the better time we have to consider it is better for the court and for counsel. But as I understand it, even the December 6th date now is passed because there's been no warrant. So it's at minimum a December 6th, but it's clearly the 4 weeks can't be honored for that, and so it's sometime beyond the 6th. Is that correct?
That's my understanding of the law. I don't do capital representation in this state, but my understanding is that now the soonest it would be is 4 weeks from this coming Friday.
Okay.
I did want to hit a couple points on rebuttal. And the first point is just again on the fact that there's a facial overbreadth challenge. So on the 12b6 question, it is whether a non-penological interest, here protecting crime victims from observing potentially upsetting speech, can be used to justify a sweeping and categorical restriction on First Amendment rights of both prisoners and non-prisoners. And on this facial claim, the court does not just look to the rights of ACLU of South Carolina, but also to the other speakers affected by this policy, prisoners and non-prisoners alike. Because this justification doesn't survive Turner or Martinez on the first prongs of either, the district court was wrong to dismiss the claim. The court should reverse. The second thing I wanted to bring up is just the staggering hypocrisy of how SEDC enforces this policy. On the one hand, they argue that a categorical ban is the only way to achieve their security interests. But on the other, they routinely disseminate recordings of conversations with SEDC's most high-profile prisoners directly to the news media. And then more recently, and this isn't in the factual record because it just came out, I believe, earlier this week, but potentially last week, a piece came out from a local news outlet showing that SEDC is more than willing to allow prisoners to be directly interviewed by the news media if it fits their ends. In a piece by News 19, SEDC allowed a video interview with an SEDC prisoner for the purposes of extolling a prison program that allows incarcerated people to work with retired racehorses. Finally, I wanted to bring up something from the
Well, let me ask you about that question. It seems to me, if we accept the notion that notoriety is one of the issues inherent in the policy, and that notoriety can lead to cliques and uprisings and organization of prisoners and discrimination among prisoners, it seems to me if the interview is about a prison policy that's working, that the prisoners are satisfied with, the state's satisfied with, that would be something beyond and different from the policy consideration. I mean, basically, your organization makes no bones about it. You want to address the capital punishment issue and increase the public debate, which is all very legitimate. But the question is whether that serves the prison policies, whether that interferes with the penological interests.
Yeah, and I'm saying that SEDC has already determined that it does not. And so in releasing these recorded conversations of Ms. Smith and Mr. Murdoch.
Where have they determined that it's not?
So in order to release the material under our state FOIA statute, which is how they represent their allowing the press to have access to that, it relies on a determination that it does not affect internal prison security or administration. There's a specific FOIA exemption that allows SEDC or other state actors to withhold information if it implicates those concerns. And so by sharing these recorded conversations with its most notorious prisoners, SEDC is making a value determination based on its discretion on security order and rehabilitation, that disclosing those recordings does not implicate those interests. The last thing I wanted to get to before I run out of time is this voice actor argument that was raised in defendant's brief. And with respect to Mr. Hall, I think that sort of gives away the game. By conceding that SEDC does not have an interest in suppressing the actual information being conveyed, only the sound of a prisoner's voice, that's a stunning admission. The sound of a prisoner's voice does not raise new security concerns. It raises no issues of prison resources. It has no role in rehabilitation. By agreeing that this is about who is saying it and not the penological interests around what is being said, SEDC is confessing that the policy violates the First Amendment.
All right. Thank you, Mr. Cheney. Thank you for the arguments. We are happy to have been able to schedule this special session with the cooperation of counsel, and of course, counsel have both made very fine arguments. We'll take it under advisement and send out an opinion on this. Many thanks, and if the clerk will adjourn court, appreciate it.
Thank you, Your Honors.
Thank
This
you.
honorable court stands adjourned, sine die. God save the United States and this honorable court.
Thank you.
All right, so I
Judges,
guess, pardon me?
I'll work to remove everyone so you can conference in private. If everyone can leave the
Okay.
Zoom, that would be great. Thank you.
Yeah.